Anna Nicole Smith, the late model and actress, made a name for herself in the pages of Playboy magazine when she was featured as the 1993 Playmate of the Year. 4 years after her death, she's also having an impact on the U.S. court system and the bankruptcy practice. In June, the Supreme Court issued an opinion in a case involving a dispute between her estate and that of her oil mogul husband, J. Howard Marshall, that has major implications for bankruptcy practitioners. Here to talk about that case and other bankruptcy decisions is the Honorable Harlin Hale of the US Bankruptcy Court of the Northern District of Texas. Thanks for joining us, Judge Hale.
Good morning.
What was the key issue in the Anna Nicole Smith case?
The key issue was who gets to try a counterclaim that's compulsory when the claim arises under state law, the who being the bankruptcy court, probate court in Texas, or United States District Court. It's jurisdiction and authority really is what it's about.
And the outcome of that case was what?
The Supreme Court held 5-4 that the bankruptcy court didn't have Article 3 authority, so it could not try the compulsory counterclaim. They didn't quite reach jurisdiction, but they came pretty close to that.
And based on that decision, what kind of impacts do you think that's going to have on bankruptcy filings going forward?
I think it's going to have dramatic impact. We're still struggling through it right now at the bankruptcy court system, and by the time of the presentation on November 11, I think we'll have a few cases under our belt. But the question is going to be how an adversary proceeding particularly is going to be handled in the future, whether one can get a trial from start to finish in bankruptcy court, whether the ruling of the bankruptcy court then has to be reviewed by the district court, or whether the matter ought to just be sent back to state court or to district court from the very beginning. So it's going to have a lot of impact, I think, a lot of impact, at least in the first year or so while courts sort out what to do.
So still a lot of unanswered questions given the ruling then.
There really is. I just got back from a judges school where they send bankruptcy judges once a year. There was 175 judges there, and there were probably 176 opinions on how we're going to handle the cases after this decision.
Well, there was another important case that was decided recently, Reed versus the city of Arlington, and the Fifth Circuit there just a few weeks ago ruled on an issue where the bankruptcy trustee was allowed to pursue a judgment that wasn't disclosed by a debtor in a bankruptcy proceeding in order to benefit the creditors that the trustee was representing. What is the biggest upshot of that particular case, do you think?
That's a case that we've been watching, and we, being all the bankruptcy judges in the country, the Fifth Circuit writes a lot of important bankruptcy decisions, and people worried about the impact of the three-panel decision because it seemed to cut off the rights of creditor and the trustee when they were innocent in the process. This case had to do with a debtor that was committing fraud on the bankruptcy court and the bankruptcy system, and it seemed that the debtor's fraud really zeroed out a recovery for the unsecured creditors being represented in the bankruptcy case by the trustee. The new opinion, I think, is one that I think creditors certainly welcome. Bankruptcy courts, I think, if you were to poll the judges, think that it's probably the correct decision. It certainly lines up the Fifth Circuit with other circuits that have looked at this. I know that the Commercial Law League, I think, filed an amicus brief on this because their members, I think, were impacted by a decision that would basically say that innocent unsecured creditors wouldn't recover because of the fraud of the debtor omitting something on purpose from its schedule. So from my own personal standpoint, I like the opinion. I think it's a fair and right. I think it's the right result, too.
Yeah, we did file an amicus brief in that case because, as you said, it was a significant impact to our members and the clients that they represent. So I think there's a pretty
good... And you won.
And we did. So we appreciate the plug. We also appreciate your insights, Judge Hale. We're looking forward to hearing more from you, and you can learn a lot more about these and other important developments in bankruptcy from Judge Hale at CLA's fall meeting in New York, November 10th through the 12th, and we hope to see you there. Thanks again, Judge.
Thank you.